Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we discuss a very interesting topic, that is a Black Money Act. You've seen some recent prosecutions in these type of cases, but what is the Black Money Act all about? What is prosecution under the Black Money Act? And all that and more with someone who practices in this area and takes a lot of interest in this subject. I want to welcome Advocate Aditya Asgaonkar. Good to see you again, Aditya.
Thank you, Tarun. Thanks for having me.
And you must be happy because we are again back to tax. This is a subject that you like.
Yes, and I'm surprised you are the one who's correctly identified that the Black Money Act is a tax statute and not really a criminal statute.
Nice. So at the outset, I want to ask you, this is for GCs, promoters, the general audience, not necessarily a legal audience. That's why this question. What is the Black Money Act all about?
So, firstly, the name of the act is not Black Money Act. It's quite long, so I'll read it. It's the Black Money Undisclosed Foreign Income and Assets and Imposition of Tax Act 2015.
Okay.
Now, the Black Money Act has got nothing to do with black money as we understand it. There are earlier judgments of the Supreme Court also that refer to, these, whenever someone thinks of black money, they think of large piles of cash that are put inside a bed.
Yes. Or, that's what the traditional...
Yes, and if recently Bollywood is to be believed, then, when you break walls, suddenly all these notes fly out. No, but that technically wouldn't get covered under this act. This act is very clear. The act doesn't define black money also. But in the preamble, I found it because I was looking for it specifically because when I was discussing it, I said, what's black money? Why is it not in the definition section? And it is an act that defines black money as undisclosed foreign income and asset.
Undisclosed foreign income and undisclosed foreign assets.
Correct.
Okay. So this is what is Black Money Act is equal to undisclosed foreign income A and undisclosed foreign assets B. Not cash lying somewhere.
Not cash lying somewhere.
Thanks for the clarification because this is a general perception was that. Now, if you could go on to explain who all are covered under the Black Money Act.
So, technically, anyone who is a resident in India for tax purposes is covered under this. The Black Money Act can get triggered by anyone who is resident in India, tax resident in India. Okay, because then you have non-residents and not ordinarily residents. So, those don't get covered. Resident in India gets covered. But interestingly, it is also a resident in India who has undisclosed income or undisclosed asset outside. It would not apply to a normal person who does not have any asset outside. And it gets more interesting because it would also apply to a non-resident if in the year in which he actually acquired this asset outside India, if he was a resident in India.
Okay.
So, it works both ways. The idea is that if you are tax resident in this country and if you have acquired, say a asset outside India and if you have not offered it for tax, you have not disclosed it, then you should because it has to be caught within the tax net. Because if you go to the Income Tax Act, Indian resident for tax purposes has to pay tax on his global income. So, this for me also looks like an extension of the Income Tax Act. We can look at it from various angles, but you have to look at undisclosed foreign asset and income. Now, the interesting thing is it also requires beneficial interest in this. It is not just that the asset can be on my name. Suppose my father was a US citizen or a US green card holder and he stayed there and he made some savings on which he put my nomination. Technically, according to the act, if that nomination was mine, I have a beneficial interest in that asset, I think I still have to disclose it under this act.
That's nice. But can you sort of explain to the common viewer, one thing is that resident is equal to citizen?
No.
Can you explain that a bit?
So, residency for income tax purposes is, you have to open the Income Tax Act and usually it is 182 days, etc. There is a huge qualificatory criteria for being tax resident in the country. There is 182 days in the year. Then the number of days you will have spent in the year in the preceding years. So, there's a lot of, it's a fairly technical section in the Income Tax Act that determines whether you are residents for the purpose of tax in India. It would have nothing to do with, everything else, whether you're actually living in the US, whether you're living in India. If you have completed that qualificatory criteria of being in India for those many days in this year and those many days in the previous years, then you are a tax resident in India.
Thanks for telling me. Now, could you explain us prosecution under the Black Money Act? Could you detail that for us?
So, prosecution under the Black Money Act is of multiple types. Firstly, I'll just give you a brief background of what can happen, right? If I have undisclosed foreign assets somewhere or foreign income outside India, I have to declare it in my return of income.
Every year?
No, at least in the first year, because obviously in the next year it will continue. If I've declared it in 1 year, you've declared it.
Yes.
Because that asset is considered to be assessable in the year it is discovered by the assessing officer for the first time.
Got your point.
So if it comes to the notice of the assessing officer in 2020 that I have got an asset in 2016, he can assess it to tax in 2020.
Got my point.
Because technically, he's an Indian assessing officer. If I have something in some foreign jurisdiction, he will not have direct knowledge about it necessarily. So it will come to him when it comes to him. It will be assessed at the value for that year. So if the market value, he will not see 2016. He'll see 2020 value and assess it to tax it that year. For this, usually, you need to file a return of income. So if you do not file a return of income and you are supposed to under the act, because you have to disclose this, then there is a prosecution. 3 months to 7 years.
3 months to 7 years.
Yeah. Then if you have not given proper particulars you file a return, but you've not made proper disclosure, then again there is prosecution. Right?
Okay.
The worst, however, is evasion of tax.
What is that?
So if you have deliberately done something to either evade tax, in the sense you've cooked up some books of accounts, you made some false entries, you've tried to hide something, some manipulation to hide it, then that is evasion of tax. So this section is, section 51 of the Black Money Act is very close to 276A of the Income Tax Act. So out there also they talk about evasion of tax. So if you try to evade tax by doing some positive act in order to hoodwink the authorities, then that is a very big problem, because evasion of tax with an intent involves prosecution, and that can go up to 10 years.
10 years?
10 years. Maximum sentence is 10 years.
So, if you could give me an example of evasion.
Very simply, I have had money abroad, right? I have bought a nice big... why go to money and bungalow abroad? Let's just say I have a Swiss bank account. I don't, for the record. But if I suppose I had a Swiss bank account and I have not been able... I have hidden how the money has gone there.
Okay, how it found its way there.
Correct. And if that income that has come to me, I have tried to hide that it has come from the Swiss bank account.
Okay.
Or suppose, let's go back to the bungalow example. If I have a bungalow in the UK bought from money whose source I have not disclosed or, not offered for tax, and I'm getting rental income on it, I will obviously receive it maybe in my UK bank account. I will still have to do something to integrate it back. No, I will get the money back. So if I made false entry in the book, then I try to evade the tax. If I've done some deliberate action.
Can you tell me one thing? In the past 3 years, a lot of people bought houses in Dubai.
Correct.
Many times, how the money went there, nobody knows. Is that a fit case for Black Money Act?
Well, it would depend on the facts of the case, because I believe there are newspaper reports that people bought it off credit cards.
Is that so?
Yeah.
But they say that sometimes crypto money, money sent through means other than the official banking transaction, hawala in local colloquial language. Does that then count under the Black Money?
If it is hawala, of course, because it has to be an undisclosed asset. If arguably, if I can show the source of the fund and I can show that it has been purchased by tax-paid money,
there is no problem.
Well, the act is still very new, but I think that is a valid defense given the wording of the act, that I am not, because an undisclosed asset or income, I should be able to show the source of it.
Got your point.
If I can show the source is legitimate money, I think that would be a good exception to this. So in Dubai property, suppose I have bought it from my money which I have offered to tax in India, that could be a very valid defense, right? But there is a second aspect to prosecution. Coming back to prosecution, one is obviously evading tax.
Yes.
Second is evading payment of tax.
Which is what?
So under the Income Tax Act, and this is what you do is when you file a return, you self-assess your tax, right?
Right.
If you ever filed an income tax return, you know that, right at the bottom, there is a tax liability and you have to pay that tax liability. That is a tax liability that you have determined by yourself,
right,
without the department looking into it. And I don't try to pay it. Suppose I do not pay it. Suppose I have 10,000 rupees in my bank account, my tax liability is 900, and I send that 10,000 somewhere else and I say, listen, I can't pay this 900. Then that would be evading payment of tax. So evasion of tax would be different from evading payment of tax.
Evasion of tax versus evasion of payment of tax. Right.
Which also is there in the Income Tax Act also. These are again two different sections. So evading payment of tax is another offense. And then there are obviously other smaller offenses. But the biggest one is this 51. According to me, the most difficult ones that you will face would be evasion of tax and evading payment of tax. And the most technical one would be non-filing of returns and non-disclosure.
Right.
If you not file your return, you would have very little defense in it, if a full-blown criminal trial takes place.
Point taken. Now, if we come to the penalty aspect of it,
yes,
what is the penalty for non-disclosure in case you've been found to be evading tax?
So, this is where, we go back to the prosecution issue. Just like there is prosecution for non-furnishing of returns, there is penalty for non-furnishing of returns also.
Penalty. What is that?
Correct. 10 lakhs.
10 lakhs.
10 lakhs. Now there are CBDT circulars and different guidelines that bring out some exceptions. But if that penalty can be levied, it can be up to 10 lakhs. Okay. Now, one is non-filing of return. Second again is for not giving proper particulars in the return.
Okay. Which is what?
So this would require a little bit of discussion.
Yes,
because non-filing of return is simple.
Yes.
I did not file my return. I did not file my return. But when it comes to non-giving of particulars, it gets very murky because you have to disclose foreign income, foreign asset, and beneficial interest also.
Okay.
And in your return, there will be a FA schedule.
FA schedule.
FA schedule. You have to disclose it in that. Now, there are ITAT judgments that have already come up, Income Tax Appellate Tribunal judgments that say whether if I've disclosed in my return but not in the FA schedule, whether the penalty will be leviable or not. I mean, the law will develop. I think this will go up. Thing is, obviously, a lot of it would not go to the Supreme Court because the penalty is 10 lakhs. The cost of litigation would be more than the entire penalty.
Yeah, right? It makes no sense.
Correct. Yes. It makes no sense. So, ITAT, I think, would be the final word on this. But the interesting aspect of this is going to be that if you have not disclosed something which you are supposed to disclose, then obviously you have not given complete information. You have given wrong information. So, this penalty will come.
Very interesting. Now we come to one of the final questions of today's show, which is very interesting because we see a lot of PMLA being invoked these days.
Correct.
And Black Money Act and PMLA, how do you see them meeting? What is the interplay between these two laws? Or do you see any action that way happening?
See, I think finally when it comes to deciding whether to take action under the PMLA or not, the final call rests with the ED.
Yes.
Okay. Whether Black Money Act proceedings can actually lead to any proceedings by the ED, the answer to that is yes. Because if you have a basic working of the PMLA, you know that it all hinges upon this existence of a scheduled offense.
Scheduled offense.
So you have schedules to the PMLA. Part C includes Section 51 of the Black Money Act. And that is why we dedicated a bit of time, earlier talking about that evasion of tax. Evasion of tax is a scheduled offense.
So basically, evasion of tax is a scheduled offense, so fit case for ED to take over investigation if it thinks.
It would not take over investigation. It would launch an investigation
parallel
into the money laundering. It would be parallel proceedings. So the Black Money Act is administered by the Income Tax Department. The PMLA would be administered by the ED. And they would both go on and on.
So in the same way, if the scheduled offense is quashed, the EDs will stop.
Of course.
But that happens?
It could happen based on the complaint that is actually filed. See, it would be very, very factual. Whether you have done evasion or not. What steps have you taken? There could be a case where something that looks like evasion might not be evasion. Like for a simple example would be a lot of this evasion actually happens through manipulation of books of account.
Yes.
That is the most common thing that ED is taking action on today also.
Yes.
But manipulation of books of account, there are some things that can be interpreted in two ways. If I've actually disclosed, but the person thinks that no, this looks manipulated. But if I can show that it's not actually manipulated, that it is say as per accounting standard, or it is as per generally accepted practice, or see, I have actually disclosed this.
So you mean this could lead to false prosecution? Have there been cases?
Tarun, this law right now is still in its infancy.
So we are still to see the full play.
To see the full strength of the black money.
Tell me one thing. Would you foresee a lot of prosecution under this act, or not much is happening, or you see that a lot of prosecution?
No, I don't see a lot of prosecution happening right now. And I think that is because a lot of people are still coming to terms with the act. See, I still think that though the act is fantastic in its objective, the definition is so wide.
Tell me one thing, just for my knowledge. Assets created abroad prior to the introduction of the act are liable for prosecution?
Yes, because in 2004, when the act came in, you had a window to disclose.
Oh, so it doesn't mean that you had acquired before, so you have an immunity from prosecution.
Correct. So when the act came in, the government gave you a window to disclose. If you have disclosed, then it is not undisclosed anymore.
Then it's disclosed asset.
Then it is disclosed. See, the idea is not to punish people for having assets abroad. The idea is that if you are hiding something from the tax authority,
you should have disclosed it in 2014-15.
Yes. And according to me, we look at it as black money, prosecution and all that, but it's basically a taxing act.
But tell me, if somebody ignored it or did not realize it, is there any remedy?
Well, you would have to disclose at some point of time in your return of income. According to me, that would help you, get away from the harsher prosecution. Because if you have disclosed it later, at least you can show that I didn't have an intention of hiding it. The problem is, if I don't disclose it earlier, and because I didn't disclose it earlier, I sit pretty. Tomorrow it comes to the attention of the officer, then obviously it looks extremely damning.
Right.
So I have this new mantra, which I use for every time. When in doubt, disclose.
Disclose it. But that's it. So, but you mean if you show your honest intent?
Correct. Because disclosing in the return does not lead to an imposition of tax.
Right.
Under this act, or even under the black money, under the Income Tax Act. If you've undisclosed this thing, foreign asset or income, that would lead to an imposition of tax. The tax rate is 30%. But here's the deal. If you've not disclosed, there is a 3x penalty. 3x penalty.
If the taxman finds out.
Of the amount of tax that you have to pay.
So it's more than your income.
See, the mathematics is fairly the same, but it could go because that the penalty provision is not compulsory. It gives your assessing officer discretion by using the word may.
Okay, so basically he may not, or he may do 2x, he may do 1x.
He will see the merits of the matter.
And then he'll go on for it.
Correct.
So thank you. This was a very quick explainer on the Black Money Act. 5-6 interesting questions. I think it would be easy. It was easy to understand for me and for all the promoters watching it. We'll come back to you in the next show with a few more detailed questions on this. But as an explainer, this was fantastic. Thank you for your time and thank you for sharing this with all of us. So that was Aditya Asgaonkar today on Legally Speaking with Tarun Nangia, discussing the Black Money Act. I enjoyed listening to him and understanding the Black Money Act. I hope you did too. Thank you, Aditya.
Thank you so much, Tarun, for
Thank
having
you.
me.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.